Hey, welcome back to block number 3. This is going to cover the Fourth Amendment from the Bill of Rights. More specifically, we're going to look at Supreme Court cases from the Fourth Amendment. I know what you're thinking. What about the Third Amendment of the Constitution, which is where soldiers aren't able to come into people's homes? The reason why I don't cover the Third Amendment is because it's real black and white. It basically says no U.S. troops are allowed to go into people's houses and stay there. There's no gray area interpretation. Whereas this amendment, the Fourth Amendment, I would say is probably the most gray and open to interpretation amendment there is. And it continues to be, and most likely will continue into the future. So let's go ahead and just jump in and take a look. So I'm going to jump right to our PowerPoint, which is right here. And let's take a look at the Fourth Amendment. So here is slideshow from current slide. The Fourth Amendment of the Constitution. So here's what it says. And you can read along with me if you'd like. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be searched. So essentially kind of the core of what this Fourth Amendment is getting at is people just having the right to a reasonable expectation of privacy, especially in their homes. A lot of this came from during pre-American Revolution. There was a specific case where it was something like, I want to say the guy's name was John Wilkes or Wilkes. He had wrote something not very nice about the King of England at the time, and the king was like, find that person, I think he did it. And they searched like every house on the block, and he kind of during his trial was just like, that's not very fair that you guys just got to search everyone and didn't get a warrant or didn't do what you were supposed to. So a lot of this was just the intent or reason behind it was to try and protect people's privacy. So that's kind of what that first part is getting at. Like, there's going to be certain rules if you are going to search. And if you are going to, you're definitely going to have a reason. That's that probable cause. And if you are going to have a reason, especially if you're searching somebody's house, you're essentially going to need to get a warrant from a judge. Show the reason why you think that they're in trouble, and then get permission from a judge to be able to search. We're going to see where that throughout this whole video, how that looks different in different places. So let's jump on into the Fourth. Oh, there's a little political cartoon where it's Uncle Sam again. We have Uncle Sam coming through at an airport. There's a TSA searcher, and he's saying, or they're saying, I said everything. And then you can see the Fourth Amendment. So here he is just questioning like his Fourth Amendment. Where does your Fourth Amendment begin? Where does it end? Is it different if you're at the airport versus if you're in your car versus in the house? So before we do anything, I do want to give credit. This PowerPoint that I am using with you today, I did get it from Mr. Slater. Thank you again, Mr. Slater. Your unit was awesome. I took and put some tweaks on it. I got some help from Ms. Martinez as well, who also helped me to add some really cool things to it. So just want to give credit where credit's due for this presentation. It's definitely an awesome one and really helped my understanding. So thank you. I appreciate that from both of you. So we're going to look at right now some major cases that happen around the Fourth Amendment and how that impacts what we do today. So the first case we're going to look at, and before we get too far, I'm going to bop out of this and go to your unit packet. So if we are looking at your unit packet, let me stop this share and jump to this. So if you're looking at your unit packet for block 3, here's the Fourth Amendment. And right here you can see we're going to go over 1, 2, 3, 4, 5 Supreme Court cases, and you're just going to jot down some notes. Real quick, just say kind of what it's about, but really we want to get, excuse me, we want to get what did the Supreme Court decide in their decision. So follow along with me as I jump back to this presentation right here. Share from current slide. Let's go. So Weeks versus the United States. So what happened is there was a gentleman by the name of Freeman Weeks. He essentially gets arrested for his crime. All came down to like it was across state lines and it was gambling. So this was definitely like the United States government. So it was a federal case. Weeks was suspected of doing some illegal stuff with lottery tickets across state lines. And so the police show up to try and find some evidence. So they search him at his office, and what they find in his office leads them to want to get more information. So then they end up going to his house, and they actually go inside his house and they gather more evidence. Here's the problem, though. They did not get a warrant from a judge asking permission. They just felt like the evidence they had gave them a reason to go search the house, but they never officially got a warrant. So they find the evidence, and this guy was really doing it. I mean, he was doing illegal activity. But ultimately, he sues and says, wait a minute, you guys came into my house and you searched my place without a warrant. This should be unconstitutional. This is violating my Fourth Amendment right. And it went all to the Supreme Court. And what did the Supreme Court say? In an overwhelming 7-0 decision, the Supreme Court agreed with Fremont Weeks. They essentially did this thing called the exclusionary rule, which says this: if there is evidence collected without a warrant or doing it in a way that's not fair, that evidence cannot be used at trial. So when it was time to do this guy's trial, if they needed to, they weren't able to use any of that evidence since it was taken or obtained without a warrant. And so basically what this set up is that if the police are ever going to search your house, they need a warrant. Okay, our next case, Mapp versus Ohio. So in Ohio, their police were on the lookout for some person with something with like a fugitive that escaped, and they had evidence suggesting that he was, or they were hiding out at Mapp's place. And so they go in to search. They knock on the door and they're just like, we're the police, and we think that this person's in your house. Mapp was savvy with the rights, and she's like, I don't think so. You can't just come barging into my home and searching. You need to show me a warrant. So the cops just like, okay, we'll go get a warrant. And they go out to their car and they're like, hey, why don't we just make a warrant real quick? So they basically make like a fake warrant. They come back, knock on the door, and they're like, here's the warrant. And she's just like, let me see it. And they're like, no. She's like, let me see it. And so she grabs it from them. They struggle. She goes to the ground. They cuff her and arrest her, and then said she was being belligerent or aggressive. And then they proceed to like search her house and search and search and search. And all of a sudden they find these illegal magazines in her house. And they're like, we're busting you for these magazines. Mapp sues, said these guys took these magazines and got them without a real warrant, and went all this the way to the Supreme Court. And the Supreme Court basically said that even in state trials, it's the same thing. Police are not allowed to use evidence that is gained without a warrant from a judge. Now, I know what you're thinking. What's a warrant? Basically, a warrant is where police are supposed to go to a judge. They're supposed to give the evidence of why they think that person is breaking their law, and then the judge is supposed to use their discretion if they can violate the person's privacy by going into the house with the warrant or listening to a phone line with the warrant. But it has to go through the judge, and the judge has to be able to say if there's enough evidence there to be able to grant the warrant. Okay, so basically these two Supreme Court cases set this precedent that said if the police are going to use evidence, they have to get it with a warrant. If they don't, they're not going to be able to use it in a trial. Next case, Roe versus Wade. This case happened in 1973. This case really got into the privacy issue. So basically, Roe was a woman from Dallas, Texas, who became pregnant and wanted an abortion. However, there was a Texas law that said she couldn't. So she appealed and said, I should be able to get it, and waited, and eventually the child is born because it took so long to get to the case. But then she sticks with it and basically says, I should have had the right to do this, and it goes all the way to the Supreme Court. The Supreme Court and the justices that were going against Roe ultimately said that the 14th Amendment of the Constitution, which gives equal protection, meant that the unborn fetus inside her stomach should have been protected like its life should have been protected. The lawyers for Roe said, and the other Supreme Court justices agreed, that within the first trimester of the pregnancy, which I want to say is like the first 3 months of the pregnancy, a woman has the right to privacy, and she has the ability to make that decision with her doctors. The Supreme Court did kind of go on to say that if it's in the second or third trimester, that each state can decide what that looks like. So this kind of came down to the privacy. Does a woman have the right to privacy in terms of stopping a pregnancy or not? And the Supreme Court upheld that women do in fact have the ability to do this, and that as long as in the first trimester they're able to do that. Each state is able to make its own laws around what that looks like in terms of like the second and third trimester, but that first trimester essentially is kind of supported by that Roe versus Wade case. All right. Kylo versus United States 2001. This is a fascinating case. I'm actually going to play you a video clip and have you watch it, and then I'll kind of jump in and explain what's going on. But just to set it up, so the guy's name is Danny Kylo. I've heard him pronounce that in interviews he's done, but in this video they pronounce it Kilo. But Danny Kylo was a gentleman in Oregon, as you can see right here. And basically, at the time, way before marijuana was legalized for medical purposes or recreational in any state, it was completely illegal across all states, as far as I understand, in 2001. Maybe there were some states that were popping up with recreational, but definitely not recreational. Either way you slice it, Danny Kylo was growing marijuana plants in his house, and there was some suspicion that he was, and so police used a thermal imaging camera to check it out to try and get probable cause to be able to search his place. And I'm going to show you this video clip, which it's what's the word? It's like a cartoon, but I think it does a pretty good job of showing what this looks like. So the video's a minute long. I'm gonna play it and then I'll let you check it out. So here we go. Let me get the share up. All right, here's the video. We'll see if it plays or not.
My name is Danny Kilo, and I'm growing some drugs. So I have 99 grow lights plugged into 99 electrical plugs. Luckily, it's my little secret, because I'm safe in my home. I haven't told a soul, not even my garden gnome. My name is Danny Lee Kilo, and I'm growing lots of pots. But because I keep it all inside my home, I'll never get caught.
We're outside Danny Kilo's home. We want to raid his home.
Well, do you have a warrant?
I could, but I don't. It's okay. I'll get probable cause now. Look, I see some evidence of drug grow lights over there.
I don't see anything over there.
Are you using a thermal imaging camera?
Nope. Those things aren't that common. Most people don't have one.
Whatever. Let's just raid him now. I got my gun.
Oh my gosh. The end. So what that video showed is basically the fact that the police used a thermal imaging camera to look into his home and find out that he had drugs. And they went in there and sure enough he had the drugs. So he was breaking the law. Now he sues and says, wait a minute, that was an invasion of my privacy. And in a 5-4 decision, the Supreme Court agreed with him. They basically said, you know what, you're right. Not everybody has a thermal imaging camera. So it's going a little bit too far for the police to go get it and peer in. And essentially that evidence was not able to be used. And it's not like they just gave the marijuana plants back to him either, though. They destroyed the plants, but he didn't get in trouble and go to jail because they didn't have any evidence to kind of get him in trouble with. So that reasonable expectation of privacy was set up. And I think actually there is evidence that the cops crushed the garden gnome they had out front, strangely enough. So yeah, this kind of is a Supreme Court case that just kind of shows a little bit more protection for the people. It was seen as a violation of Danny Kylo's Fourth Amendment. All right, our next one we're going to look at is United States versus Jones. Antoine Jones basically was a nightclub owner, and the cops were getting some kind of information that there was a chance that he was selling drugs through his nightclub. So what they did is they went and got a warrant, which so far so good, right? I know what you're thinking. They'll be able to use the evidence that they get it, but here's the problem. The warrant was for a limited time frame, and Jones, the cops used, oh, sorry, I'm going to back it up a little bit. The cops went and got a warrant because they wanted to put a GPS device on Jones's car. So they did this, but the problem is when they put the GPS device on the car, it was outside the time frame that the warrant was for, and the warrant was for a very specific area, and Jones drove outside of that area. So the cops get all this evidence from the warrant, even though they didn't follow the warrant. They had enough evidence to prove he was in fact dealing drugs, which he was, and they swooped in and arrested him. And what did Jones do? He said, I don't think so. You broke my Fourth Amendment right. Why? Because you did not follow the warrant. And in I can't remember exactly, I think this one was pretty close. The Supreme Court essentially came out and said, we agree with you, Jones. The police did not follow the warrant, so this cannot be used in court. And so they didn't have enough evidence, and he was, I think his conviction was overturned. So those four cases give you a little bit of an idea of what's going on around the Fourth Amendment and how the different interpretations have come out. So here's what you're going to do for the rest. What I want you to do is in your unit packet planner, if you start scrolling down, this is a reading that goes over, oh wait, sorry, I have to get my share screen on, make sure I'm sharing the right screen here. So let me go ahead and share my screen with the planner. So if you look in your Bill of Rights unit, here we go. Hopefully you're able to jot down some notes for each of those. You're gonna just do a quick reading of some general information about the Fourth Amendment. And then you are going to see kind of a whole lot of reading. And I'm gonna show you one last thing. So here's a bunch of reading, but I'm actually gonna zoom to the last page. So if you look on the last page, this is kind of like a note catcher, and it's set up with what the Fourth Amendment looks like in public, what it looks like in somebody's cars, what it looks like with home searches, and what it looks like with searches and seizures in schools. And you'll notice it says case 1, case 2, case 3. So what you're going to do is I just want you to go through, and let's just say for public, if we scroll back up to public, there should be a picture, I think it's like of a shopping mall. Here it is. Searches and seizures in public. So the Fourth Amendment looks different in public. And here are 3 Supreme Court cases: Terry versus Ohio, Cass versus United States, and California versus Greenwood. These are 3 Supreme Court cases where things were searched in public, and you could see what the Supreme Court said. Now, if you're doing this alone, I'm just going to have you pick one of these 3 and take notes on it. If you want to do more than that, you can, but I just want you to pick one. So for searches in public, go ahead and pick one of the Supreme Court cases and take notes on it. Then if you scroll down to searches in cars, you can see 3 more Supreme Court cases. Case study 1, Carroll versus United States. Number 2, and number 3, the Arizona Supreme Court case there. So again, read through these. They are examples of how the Supreme Court has ruled with cars. And then after that, you are going to scroll down to searches in homes. Same thing, there's 3 Supreme Court cases, number 1, 2, and 3. Pick one of them, take notes on it. Last but not least is searches in schools. So here's 3 more Supreme Court cases. 1, 2, 3. Pick one, take some notes on it, and that's pretty much it. The one thing I'm hoping you're going to get is as you take your notes, you're going to see that depending on where you are, the Fourth Amendment kind of changes. It is the most lenient in public, in between with cars, and basically it's the strongest for somebody's home. So if you're in your house, that is where the Fourth Amendment is the strongest. It's where you have the most privacy and the most protection. The further away you get from your house, whether you're in school or in your car, especially in public, the less and less privacy you can expect based on these Supreme Court cases. So that's pretty much all I have for the Fourth Amendment. Like I said, fascinating amendment. It's definitely the most complex, gray one, very open to interpretation, and I'm sure it will continue to be. That's it. Thanks so much for coming to the video. We'll see you later. Okay. Bye.